أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على رسوله الكريم وعلى آله وصحبه أجمعين وبعد Assalamu alaikum wa rahmatullah everyone. My name is Mariam Khan and I'm the founder of the Muslim Educator Academy. And today we are having a webinar in coordination with the AMCC Community Center in Longwood, Florida, and hosting a few speakers from Dawood Sohail Law. And the topic of today's webinar is planning for the unexpected. And the purpose is to introduce wills, trusts, power of attorney, living wills, and the COVID-19 stimulus package. First of all, thank you so much for joining us. We know we put this out in short notice, and so we hope that this information will help you during this difficult time. We also want to thank AMCC for getting the word out, helping to host this virtual seminar, and we reached out to them just a few days ago to Dr. Shakil, and he helped us get the word out and put this out in just a few days. So obviously right now we're living in a difficult situation. You know, things are being confused. You know, the situation is confusing. People are all around us are scrambling to figure out situations with their employment, health situations. And so what we thought we would do is to get together and discuss some things that really, under normal circumstances, we really should have already, you know, prepared for, you know, things like death and, God forbid, being incapacitated. But oftentimes we put off, and now the situation is such that we really need to confront that head on. So, you know, obviously you know, from an Islamic point of view, we are also focusing on the spiritual aspect, you know, the spiritual aspect, and, you know, increasing our supplication, increasing our dua. And so today we're going to focus on the tying your camel aspect. Really briefly though, before we start, we just wanted to mention that, you know, in times like this, let's always make sure to keep those who are struggling and who are in difficulty, to keep them at the front of our thoughts. We encourage you to go to your local communities and reach out and support those who are in need right now, because you never know, people are struggling in ways that we can't imagine. So another important aspect that we want to focus on is reconnecting with family. Now, the topics that are going to be discussed today are very difficult topics, very difficult to think about, let alone discuss with others. So, you know, putting this aside even for a minute, just bare minimum reconnecting with family first and foremost is the most important. And then secondly, being able to sit down with family and have these tough conversations. It's going to be very important. It's better to go through the difficult conversation now than later, when it's too late. If you take a look on your screen, there's an option to raise your hand. There's an option to submit questions. So I encourage you to use those options on your screen so that you can submit any comments or questions. We're trying our best to make this interactive, and so we can get the questions answered. And so please just let us know. You can also post it. Those who are on the Facebook Live, you can post your questions there as well. All right. So moving on, the two main topics that we're going to hit today are the idea of an estate plan, as well as the estate plan in combination with the powers of attorney. And then secondly, we'll go on and discuss the stimulus package. So the question is, why is this such an urgent topic right now? I mean, everybody's following on the news. Everybody knows what's going on. What is unprecedented about this situation currently is that You know, you have thousands, literally thousands of people who are becoming ill and deteriorating very rapidly. You know, people are not having time to think about uh, their medical directives. They're not having time to think about things like wills. Things are happening so quickly, and oftentimes, what we're seeing now is that people are passing away without even getting a chance to say goodbye to their family. And so really this is makes it a very complicated situation for many people, because once they pass away, their family is left behind to pick up the pieces, not only emotionally, but then financially as well, in terms of dealing with their estate that they leave behind. We also have a situation which has become more common than in the past, which is that of both spouses dying at the same time or within very short periods of time, because they're living together, oftentimes get sick together. Unfortunately, oftentimes it's the elderly. And so that makes the situation even more complicated, because you know they're both in a situation where they cannot, you know, who then is going to make those decisions about care, who then is going to determine what happens to their estate. It becomes a big problem. um, Furthermore, you know, people are in a situation where they're not able to communicate for weeks on end. You know, as you're hearing the crisis of ventilators and people being on artificial respiration for weeks at a time, that means they're sedated. They cannot, it's too late to communicate at that point. So we all want to make sure that everyone has their wishes decided in advance, and that it's legally set, so that you're not stuck in a situation where you know you can't do anything about your wishes. Your wishes may not be respected. A family member's wishes may not be respected. So uh, furthermore, and another issue that we will get to is the idea of finances. You might have a family member who is sick, and they are, again, cannot communicate because they're on a ventilator. And so now, who's going to pay their bills? Who's going to pay their loans? Uh, their payments might become delinquent, and then they're going to run into issues. And if you try to call and figure out what's going on, no one will talk to you, because you're not an authorized person to discuss their accounts. You can't go to the bank and access their accounts, right? So we're going to get into the issue of the powers of attorney. And so with that, I'm going to pause. That was my introduction. I'm going to leave it to our attorneys, Zubair and Siraj. They are the attorneys of the Dawood Sohail Law. They're both licensed in the state of Florida. They have been working, practicing law here in Florida for a few years. Prior to that, Siraj was working in higher education in the admissions and registrar office of Thomas M. Cooley Law School. And Zubair has been running large businesses for many years. And one of their specialties is estate planning. So with that, I will ask Zubair to go ahead and tell us about, just explain to us what happens when someone dies without a will.
Assalamu alaikum wa rahmatullahi wa barakatuh. I just wanted to start by saying Jazakallah khairan to AMCC and all the participants today for taking time out to attend this webinar with us. And I wanted to start off with just a small story to kind of illustrate, to bring the point home about the importance of planning before someone passes away. And so I've been familiar with a situation wherein there's a family structure where there was a husband, and he had one wife, and he had 4 children. He subsequently got divorced from that wife and married another spouse. And with that spouse, he has 1 child, 1 boy. And he, over the period of his life, he amassed a significant amount of wealth. And he had type 2 diabetes as he was elderly, and he became very sick to the point that he had to be hospitalized. And at this particular point in time, he had no estate planning done. He had no will, no healthcare directive, nothing of that sort. And so what he attempted to do was give a verbal will to another member. And so he told this other person, he said, I want to make sure that my children from my first marriage are taken care of, that they get a share of the distributions. And I want to make sure that my current spouse, that she gets X and my current son gets Y. So he wanted things to be done in a specific manner, but he only had basically a verbal quote unquote will. So he deteriorated and he went in and out of consciousness, and to such a point that he wasn't unable to communicate at points. And then he eventually ended up passing away. He passed away with nothing other than that verbal will that he had relayed to that other member. So fast forward, basically there had been communications between the deceased his second wife and the children of the first wife. And there was several discussions wherein the wife said that she just wanted a house for herself and some additional funds for her son. And immediately that the children from the first wife, they said, no, we want more, etc., etc. So there became this dialogue between the two parties and kind of almost fighting over the wealth situation. And what ended up transpiring is that the second wife, went to basically an attorney and kind of tried to see what she could do, what her remedies were. And the attorney basically said, you are in the driver's seat in the situation. Basically, you're entitled to a significant amount of the funds. So what ended up happening is that they're in current dispute till this day. So this has been going on for several years now. The husband is deceased. It's been deceased for several years, and there's no end in sight because they're still fighting, and it's going through the legal system to make the determination of who is going to get what. So instead of what the father had said orally to that individual member, that's not going to come into any effect because it's not legally recognized. And that's something that's going to be important to understand, that if you have something, whether or not you write down a piece of paper and you put it somewhere, if it's not done correctly, it's basically worthless in the court system. So I wanted to illustrate, to begin with that, just to kind of set the groundwork for the importance of planning before something happens wherein you are unable to communicate, or you're unable to set up these plans that you can distribute your wealth the way that you request and the way that you want. So I want to pass it back to Siraj, and he can kind of go into a little bit more details on the structures of wills and things of that nature.
Thank you very much, Zubair and Mariam. Assalamu alaikum. I also would like to thank AMCC for allowing us to present this on such short notice. It's very generous and kind of them, and we hope that the community, wherever you're listening to, you benefit and you find some tangible, practical knowledge that you can use realistically. So many times when we speak to clients, they might tell us, oh, I don't have a lot, my family's not going to fight over what I have, or it's not really worth my time to create an estate plan, so do I really need one? So the question which I always, when this question comes up, I make it a point, it doesn't matter what you have, a little bit, a lot, who your relatives are, absolutely everyone needs an estate plan. Everyone needs to make clear what they want to happen with whatever they have amassed, whatever they have, and what they want to, how they want to pass, and all these things, right? So some of the reasons why it's very important to have an estate plan, and we'll go over different estate plans that, are available to people. But, first and foremost, we want to have control over who inherits. Because as we know, as Muslims, Allah subhanahu wa ta'ala, He very clearly lays out who is entitled to what from our estate. This is a blessing from Allah subhanahu wa ta'ala, because there's so many fights that we see, so many courts are tied up because there are disagreements among relatives, or I want this or I want that. But for us to make sure that our wishes are fulfilled with inheritance, we have to write it down. Because if we don't have a valid estate plan, a valid will, or valid trust, or some valid estate plan, guess who gets to decide what's gonna happen to our estate? Anyone want to venture to guess? Either type it in or from the panelists.
Yeah, you can, those who are attendees, you're welcome to, you've got a box there to type. You can also click on the raise hand button
All right.
as well.
So right. So for the sake of time, the state, you have to go to court, and the court decides who gets what. And no one wants to be in the situation where a judge is the one who is deciding these type of matters for us. So with a little bit of planning beforehand, we can take care of such a huge matter. Secondly, is that we can have control over who is going to make sure that our wishes are fulfilled. Obviously, we can write, we can have so many plans, so many ambitions, so many things we want to have done. But if it's not written down, if it's not done in a legally binding way, the state at that point will decide who gets to administer it. And there's some other ones that are here, you can read them. But the one I want to focus on, which so many times we discuss with relatives and family members, is the designation of a guardian. Basically, if you have minor children, and God forbid both you and your wife pass away, or you and your spouse pass away, then who is going to raise your children? Your greatest asset, the people the children who are the apple of our eyes, who we give so much for, right? We want to make sure that even if we are not here, they are taken care of, their best interests are taken care of. So we can specifically delineate who is going to be the person to make sure our children are raised according to our ethics, according to our vision, according to how we want for our children to be raised. And if it's not written down in a properly created estate plan, then just like inheritance, the government is going to decide, the judge is going to decide who is going to be the guardian of our children and of our minors. So this is a huge matter. So for all of these reasons and others, we really should, it's this topic that people don't like to necessarily talk about or think about, but death is a reality. These things are going to come today or tomorrow. So it's better to be prepared and be planned. As they say, those who, fail to prepare, they prepare to fail, right? That applies in all aspects of our lives and in this respect too. And then also we'll talk about medical directives and powers of attorney, so, right? And then another question which comes up from a lot of people is, what are some of the goals, larger goals of estate planning? And when we talk to our clients, when we talk to people in general, whenever we're doing presentations or people come to us, we always mention that to the greatest extent possible, it is good to avoid probate. And what probate is basically, that's a legal process where your spouse or your children or your brother or your sister, he or she has to go to the court and basically file a case, right, with the judge, to basically say that so-and-so passed away. And because so-and-so passed away, he had a bank account, he might have had a house, he might have had a business. Now we need to figure out what is going to happen with whatever is left behind. And there are many negatives to having to deal with probate. One is that it's a public process. If you've ever been involved in court matters, you know that court matters are issues of public record. So I can, right now I can go on the Orange County, I live in Orange County, Florida. I can go on the Orange County website and pull up thousands of wills, thousands of family disputes, thousands of personal and private documents come up that I can view, or anyone can really view. So if we want to keep our estate private, a family affair, or an affair for a small amount of people, through estate planning, we can reach that goal. And another huge drawback of having to go through the probate process and open up a court matter is that it is an expensive and timely process. We do probate in our firm, and the most simplest probate takes anywhere from 90 to 6 months just to make sure all the assets are accounted for, all the debts are paid out, everything is done. So for 6 to 9 months, you have a legal matter hanging over your head. And that's just not on top of the sadness of losing a relative. A court matter is not something which, is very fun or exciting to deal with. And also it's expensive. Court, to file a court case, it costs several $100s. To hire lawyers, you're looking at least $3,000, $4,000, $5,000 of an estate that, if you planned a little bit more beforehand and had a trust and had a proper estate plan taken care of, you could save that money for your heirs and for your future generations. So one of the primary goals that we and most estate planning lawyers look to achieve is, to the greatest extent possible, avoiding opening a court matter. So next we will move on to yes.
So can I want to ask, could you explain the point, if you go back to well, you're going to talk about it here, about wills, and for me, as someone who's not involved in law, on a professional level, I've always been under the understanding that a will is sufficient So you're saying that if someone does have a will, they still would have to go through the probate process?
Many times, yes, just because of the fact that a will, basically, this kind of segues into a will. Basically, what a will is, it's a legal document where you basically tell your relatives or whoever what you want to happen after you pass away, right? And in this will, there's many things which we touch upon, and it's important in particular for Muslims to touch upon, is that uh, to your question about the probate, yes, because if you just have a will and you have a property in your name or an account in your name or a business just in your name, what happens is that the will tells the world what you want to happen. But for it to actually happen, a judge has to give someone the authority to make your wishes become a reality. To make your wishes become a reality. So that's kind of how it works. So yes, having a will is important. It's an important document in tandem with a full estate plan, but in and of itself, it doesn't always avoid having to go to court and open a court matter. So in the simplest terms, what a will is, as you can see here, is that it basically tells whoever you decide, call your executor of your estate, the person who's going to make your wishes come into reality, what you want to have happen. And obviously living in a non-Muslim country, it's very important that when you create a will, you can make it very clear how you want to be buried. Just yesterday, I got a phone call from a gentleman who, he's concerned because he has some non-Muslim relatives. I think he's a convert, so his parents aren't Muslim, and he has, children who are Muslim. And he's very concerned that, obviously at this point in his life, he is a devout Muslim. And he wants to make it crystal clear that when he passes away, he is buried with a janaza, he is washed, he doesn't have, the viewing and all of those things. He is buried according to how Islam wants and buried into the Muslim cemetery. So his main goal and everything is achieving this goal, achieving having an Islamic burial. So we explained to him, yes, we can put that in your will, make it very clear, these are where your wishes are. And if you sign it, and if you, do other things to make it a valid document, then that will uphold in a court of law. So are there any questions? I saw questions pop up here. Are there any questions anyone has right now? Is this going to be recorded? I believe it will be recorded. Yes, correct?
Yes,
Right.
this will be recorded,
So,
and we'll get it to YouTube as well. I will send out the email to whoever is registered that it's going on YouTube.
right. Along the lines of a will, another thing that some people, they tell me is that, I don't really need to go through the formalities of sitting down and having a will. I can just write down what I want, and that's good enough. But sometimes that is not good enough, because for a will to be valid, in every state, in every jurisdiction, it has to meet certain basic guidelines, because there is a public policy, the courts and society wants to make sure that what's written down truly is the intent of the person who's writing it down. So for example, Zubair is my good friend. I talk to him on a regular basis. I can't just get a sheet of paper and say, my name is Zubair, give me all of his money, right? And just put it in a filing cabinet and be like, look, I have his will. That won't necessarily hold up, because it is not signed, it is not notarized. So in Florida, where we are, there needs to be two witnesses who, as you sign it, they are watching you sign your will, and they know that you have a will. So sometimes people, they write down their long wishes. They want this, they want this, they want this, and they put it in a filing cabinet, and then they think, I am good, and that's going to hold up. And the reality is that that does not always hold up if the strict guidelines of how it becomes valid are not met. And this actually happened to me. Recently, maybe 6 or 7 months ago, a client came to our office, and his sister had passed away, and he had to go to court to open a probate matter to make sure that her property and everything was taken care of. And she actually had a will drafted by a lawyer. So I'm guessing she went out of her way. She had it drafted. It was typed. It was on law firm letterhead. It was as legit as you possibly could look. But then when we went to the court and we tried to present it to the judge and be like, Judge, this is what the person created. Why can't we have this work? And the judge rightfully noted that it wasn't witnessed. So because it wasn't witnessed, that paper basically, in the eyes of the judge, rip it up, throw it away. And the state was going to decide, per the probate rules, per the statute, who is going to get what. So along with drafting it, it's extremely important that it is effectuated in a way that the court will, court, society, legally, your wishes will be met. Are there any questions right now on wills?
Yeah, there's some questions
Yes.
posted. So one of the questions that came through is, for children, what happens? Do they end up in foster care?
That is a question that, there's more nuance to it. The courts, generally speaking, they like to find a relative who would be willing and able to take the child on and raise them as their own. So they'll ask, and they'll ask the person who they put in responsibility to administer the estate, are there any relatives who are willing and able to, right? And we hope that someone is, but if not, then yes, the state essentially would find a family for them. That's kind of how the process works. Yes.
There's another question. I'm not sure. The question is, assuming that I passed away without a will, which state has the most Islamic-like default inherence law?
Zubair, you want to answer that? You've been kind of shy.
That question it's kind of hard to answer in certain respects, because if you pass away in Florida, you can't apply, even if there was a state, say there was a state, I don't know, let's say Atlanta, for some reason they have adopted Islamic law as their particular law. If you pass away in Florida, you won't be able to apply that law in Atlanta. So if you live in Florida, you'd be basically tied to the laws of Florida. And generally speaking, the inheritance, the default probate inheritance, is nothing close to what the Islamic law is, because usually speaking in Florida, the default is if there's a spouse and children, normally that's going to be the end of the story. That's where it kind of stops. At the same time, where Islamically, if you have parents and you still have a spouse and children, the parents would take. So there's those very clear differences right off the bat. So I don't think that it's the best approach to kind of say which state would have the best or most Islamic-like default inheritance law. I think it's always best to kind of provide that for yourself, so that you have that set up and you have it determined prior to the state intervening to distribute the property according to the default inheritance laws.
And there's a few more questions. One of them, how do I know what do I need? Will, estate planning, or trust? They're going to get to that shortly, so just hang on to that question. Another question is, who typically counts as a witness? And another similar question that came in is, can a relative be a witness on a will or trust?
Zubair, go ahead, you can answer that.
So let me just touch on the first one. The question was, how do I know what I need for estate planning, if I need a will or a trust? One of the things is that, so when we have discussions with clients, when we talk to clients individually, we're able to assess their particular situation. And that's the one thing that I think I should have started off with, is that in these type of seminars or webinars, we try to kind of give general information, not specific, tailored to a particular individual. So therefore, it's not really legal advice to a specific person, but just general advice to the community. But when we talk to people on an individual level, we discuss with them their specific background, their assets, their current state of affairs, and we're able to make recommendations. In some cases, a will may be the best option. In some cases, a trust is the best option. But the way that we determine that is through actual individual conversation, wherein we can understand what each person's individual circumstance and situation is. So I think that would be the solution to determine what estate plan is good for you. And to the question regarding witnesses, yes, they should be, the witness should be over 18, and generally you do not want to have basically one of the beneficiaries, especially if you're doing a will or a trust, you would not want the beneficiary to be one of those witnesses.
Okay. It says, if your children are over the age of 18 but still living with you, is it still necessary to identify someone for their care? Or once they turn 18, is that not necessary, assuming they don't need a caretaker?
So once someone reaches 18, they, even if they're living with you, and if every day they say, "Mommy, what's for breakfast? What's for dinner? Daddy, can I have gas money?" No matter what they ask you, legally speaking, once they turn 18, absent, special needs situations, in the average child, once they hit 18, they're an adult. So at that point, no, it's not necessary to appoint a guardian for them. 17 and younger is where the guardian, the guardianship comes in, and that's a factor.
And similar to that, another one about the children. Can the children be sent overseas to live with grandparents in the absence of a will or even with the presence of the will?
For that one, it's a little bit complicated. I can talk to whoever it is. I can answer that, specifically to you, because there's more to it. Generally speaking, without a will, I don't think that would be a possibility per se, because issues of jurisdiction and well-being of the child and other reasons. I haven't seen that. With a will, an argument could be made, but that's a very specific question.
Okay. In addition, another question that came in is, can a properly written will, which has witnesses, be updated by the person while they are still living?
Zubair, you want to answer that?
Was
It's from the Facebook stream. Can a will that has already been signed by witnesses, can that be updated while the person is still living?
Yes.
Yes, called the codicil. Yes, you can. So what we'll do is right now, to keep the flow going, we have these questions. We can come back to them, I think. What I will do now is, okay, we have one question left on the Zoom. And Zubair, the question is, does the will need to be prepared by an attorney, or an online will is sufficient, attested by witnesses? So basically the legal Zooms and those type of options. You want to go and answer that? I know you love that topic.
I mean, you definitely, there always is an option to do legal Zoom and other Islamic, cookie cutter type wills. There is, but again, generally speaking, those do not take into consideration your specific circumstances, your ability, especially when it comes to Islamic wills, because generally speaking, you'd have to be able to know what the Islamic distribution is for your particular scenario, and you would have to be able to put that out. And some of the other similar languages, okay, so say for example, you know all that, you do that, but a legal Zoom document is not going to be able to steer somebody in the right direction if one of those inheritors predeceases the person who's actually drafting the will. And that's something that it's important to look at as well, because there is times when you can have a beneficiary, or you can have a child or something that would inherit from you, but they actually predeceased you, or they die before you. And in those circumstances, if the will is not reflected to make changes, it becomes very difficult to do that.
All right, so having said that, I spoke my piece on wills. The next, another very popular estate planning document is something called a trust. And Mr. Zubair will go ahead and let us know what exactly trusts are, and what some of the potential benefits are of trusts. So Zubair, it's all yours, my friend.
Okay, so trust is what kind of Siraj was alluding to, and it's a substitute for a will, and it's one of the tools and mechanisms you can use to avoid probate. And as Siraj had discussed previously, that one of the things that we try to do is avoid probate, because we want to keep our private matters private, and we want to make things easier than they need to be. So generally speaking, a trust is basically agreement between the person who is creating it, and we refer to them as the grantor or settlor, and someone who's called a trustee, which is basically a manager. And it's set up so it's for the benefit of a third party, being the beneficiaries, or the individuals whom you want to give your property to. So again, so you have usually three individuals involved in this, or three hats, should I say. The first being the grantor or settlor. The second is the trustee, or the property manager, if you will. And then the third is who you want to give that property to. And so how the trust works is that it's basically an agreement. It's like you enter into agreement for leases, for anything. It's an agreement between the grantor settlor and the trustee / property manager. And it says that I want you to do with this property, I want you to give it to X, Y, and Z. And it explicitly, it spells out how you want to give that property to a third party. And it is it is a great tool because it's private. It's something that the transfer is already done, and the way trusts are set up is, as Siraj had alluded to and described the probate process. It's actually the judge is giving the ability for the personal representative to transfer the property onto the beneficiaries or to those who are going to inherit. Likewise, in a trust, that's actually doesn't need to be done by a judge because you've already done it in your lifetime. So in lifetime, the grantor seller has transferred that property and has put it into the trust. So it's actually already transferred into the trust, and the trustee at the time is able to transfer that property to who the original grantor seller wanted that property to go to. So
Zubair, can I ask you a quick question?
Sure.
So suppose there's a man named Muhammad and a woman named Khadija, and they have 3 children, Asma, Zaid, and Khalid. So it's a husband and wife and 3 children, right? So practically speaking, because many of the people who come to us, is oftentimes a family with children. Practically speaking, what you just said legally, how does that work in the real world?
Okay, so in that situation, what Siraj is talking about, when you have a spouse with three children, so generally what we would do is we create something called a joint revocable trust, which means it's basically both husband and wife together to create a trust together. And while the husband and wife are alive, they're allowed to do basically whatever they want with the trust, meaning they can add things to it, they can remove things from it, sorry. And they can, honestly, if they want, they can just destroy the trust and pull everything out and make everything how it originally was in the original title. For example, in that situation, say that, the husband and wife, they had an investment property. Initially, they transferred that investment property into the trust. At any point in time, they can sell that property. They can take that property out. They can do whatever they want with it. They still have full control and power throughout their lives. And so what ends up happening as well is if one of the spouse dies, the way we can draft the trust is that the remaining spouse has full access and full ability to do anything she wants or he wants with that property while they are alive. So it doesn't go directly to the beneficiaries until after the surviving spouse passes away. At that point, there will be directions, and there will be what's called a successor trustee, will be another trustee that is designated already in the trust, who is going to take control of the property and distribute it according to the terms of the trust agreement, according to the intent and wishes of the original settler.
The mom and dad. So basically,
mom and dad.
So like, for example, the mom, dad, 3 kids, the mom and dad say, dad's brother, he is a trustworthy guy. He invites me over every Sunday for dinner. I want him to be the one to make sure that what I have in this trust is passed on. So basically, once mom and dad pass away, brother comes in and basically does exactly what needs to be done. Is that am I understanding it correctly?
Yes. So in the trust document, there's powers that are listed for the actual trustee. And so one of the powers they have is the ability to transfer. So if it's real property, if it's business, if it's bank accounts, depending on what's in the trust, the trustee will have the power to do that. And so they can transfer it to the children. So if there's, let's just say there's 3 boys in that situation, they would transfer them equally to the 3 boys.
And another question, people sometimes ask, or maybe I want to know, or people want to know, is how does this work with bank accounts? Because for most people, we have bank accounts, and we know that if I pass away and no one's there's no beneficiary, they're gonna have to go to court. So how does a trust allow for what's in your bank account to go to your children or go to your trust, your whoever's gonna take from your inheritance?
So there's a few ways to do that, and one of the easier ways is if you go to a bank and you ask them to do a transfer on death. You fill out a form and you do a transfer on death to the actual trust. And that way, once you do that, then upon the passing of the individual, the trustee would then just show the documentation of the death, and that, that he is in fact the trustee, and then they should have the access or the ability to access the bank accounts.
All right.
So we have a good question here about can the beneficiary be the trustee?
Yes. Yes, and usually speaking, like alhamdulillah, in our communities and in our families, usually that's a lot of the time we have, beneficiaries or children that are responsible parties, and so we normally name them as a trustee, and so that way, you keep the actual affair even more private, to be quite honest with you. Generally speaking, unless there's family dynamics do not allow for that, generally that's what we normally see that what happens.
We've got a question about trusts on the Facebook stream. Can a trust be updated by the grantor?
By the husband and wife, and so it's a revocable trust. So you can add. So, like for example, if someone has a trust and they buy, they become very successful in their career and they buy a second property, they can add that to the trust, and that becomes part of the trust. If that's what the question is. Zubair, there's a couple questions on the Zoom. Do you want to ask them so that we can kind of go through those two? They're trust related.
So let's do the trust ones first then. So what happens when spouses divorce during the existence of a joint trust?
Sorry, do you want to take that one?
You can go ahead.
So basically, when you're dealing with divorce, that's a completely different law in itself, and that's like a family law section. We generally don't practice family law. So just from in general, depending on if there's a prenuptial agreement or if there's separation of assets and things of that nature that have been done prior to the marriage, generally the marriage will, if there's communal property between the spouses, generally there's going to be a share of that spousal property.
Right. So many times there's a marital settlement agreement where assets are pretty much divvied up and distributed then. And the other benefit of having this type of trust is it's a revocable trust. So, we recommend just canceling that trust out at that point because you no longer are a married family. So you can cancel that trust and then it's as if it was never there. I hope that answers your question. The next question is, are there any taxes involved in trust is transferred to the children? So you want to say it's basically a tax question.
Sure. Generally, there is a estate tax if you're above a threshold. For an individual, is just above $11 million, and for us, like a married couple, is just under $24 million. So if as long as you're within those threshold limits, you should be fine, inshallah.
But if it is above, yes, there are tax consequences. At that point, there's many tools which can be used, like generation skipping trust, like blind trust, like gifts. So there's if someone is nearing the estate tax threshold, at that point a different level of planning is involved because there are tools available to reduce the tax burden or minimize the tax burden. So if someone is near that level, that's something that needs to be considered.
Now there are two questions that are related, one from the Facebook and one from here. So one of them is that, so when we talk about bank accounts, sometimes people have separate assets, husband and wife, and then the question is, if the properties and bank accounts are in both spouses' name, can the surviving spouse control the assets without a will or trust?
So if it's a joint account, legally speaking, yes. For even Zubair and I, if we have a joint account, if it's 100% his money, but my name is on there, that gives me legal authority to have access to the account. Is that what the question is?
Yes, the surviving spouse. So, assuming that only one of the spouses has passed and the surviving spouse, so if it's a property though, do they have to do anything once one of the spouses has passed? Is there anything that needs to be done in that case?
You want to say, Zubair?
It's like, just to echo what Siraj said, if it's a bank account or a piece of property, if it's done if it's done with jointly, then no, because each party, each husband and wife, they own 100%. So upon the passing of the other owns 100%.
Right. So to Arshia's question about laws of inheritance, or obviously husband and wife, separate property. Yes, we know when clients come to us, we do explain to them that if there's husband's property, wife's property, it needs to be very clear who has what, because the laws of inheritance are unique to each individual. So we sit down with our clients and we make sure that those stipulations are met. To answer your question, it's it's a little bit technical in the sense that it's unique to each person, but yes, it can be delineated out in the will and the trust. Yes, we do that.
And I think part of this goes to the importance of working with someone who who has the resources to go and figure that out, especially when it gets to situations where the inheritance becomes a little complicated according to the Islamic guidelines. Just so out of curiosity, what do you all do if you're in a situation where you know, you're drafting a will or a trust, and this the inheritors, it's not one of those straightforward situations in terms of the Islamic guidelines? How do you then figure that out when
I like
drafting?
to ask someone who has, you know, the Islamic background, just to kind of run it by them if it's something which is not straightforward. That's usually what we like to do. Zubair, you can chime in on that.
No, that's the same. If
Yeah,
we're not sure, we always reach out and trying to find a solution with somebody who does know.
generally speaking, you know, Zubair and I, we try to usually, you know, when we have these conversations with our clients about estate planning, you know, sometimes sensitive questions come up, and our general advice to our clients is that, you know, we all are going to return to Allah subhanahu wa ta'ala. That's inevitable. And when it comes to estate planning, when it comes to inheritance, that in many ways is the final act that we are going to have before returning to Allah subhanahu wa ta'ala. So we should be as careful as possible to make sure that what we're meeting Allah with in our inheritance and our final things is done as close as possible to what is pleasing and according to what Allah wants from us. And that's our general advice. Obviously, people can take it or leave it, but our general advice is that these final acts that we do, we follow the Islamic guidance on that. What is a death tax? I just want to clear up some of these questions. The death tax, as Zubair was alluding to, is that certain estates, you know, if they reach a certain threshold of the 11 to depending on $1 million, on that point, the inheritance which is distributed down, a tax applies to that. But that doesn't apply to everyone. You have to be at that level.
Then there's a question regarding what steps are needed to set up a valid trust. Just a signed and notarized document with 2 witnesses is enough. So with that, to set up a valid trust, it has to be done in the correct manner. So you have to establish the name of the trust. It has to be witnessed. If it's what they call a testamentary trust, which means it's something that's you're using it for almost like a will substitute. So in that case, you would have to follow the same will formalities that Siraj was talking about, wherein you need to have the 2 witnesses. They have to know what they're signing, and you know, you have to have a notary to notarize that as well.
All right, so I think to keep it going, because we're at 8:15 now, we do see these questions. Maybe what we can do, Zubair and Mariam, do we want to try to get to some of the material and answer these questions at that point, or if it's or it depends on how you want to do it. And just, I know that we have a few more.
Why don't we get through a little bit more of the presentation and then come back to some of these
questions. So these questions aren't going anywhere. They're duly noted, and we will certainly, you know, when we're done, we will stay and answer whatever questions come up. You know, we're stuck at home anyway, so we might as well talk to you guys and have a good time together. So we will be here to answer any questions as they come up. So are we pretty much good on trust, Zubair?
The one last thing, I think the one thing that we just wanted to talk about was the creditor protection. So one thing is, you know, sometimes we get asked this question quite frequently: is a revocable trust or a living trust, is that sufficient for asset protection purposes? And the general answer is no. So kind of a rule of thumb that we like to, you know, explain to clients is that, excuse me, the easier it is to be able to get to assets, the less asset protection you have. In a revocable trust, it's very easy to go. There's nothing preventing a settlor or a grantor from transferring or taking out anything as trust property. So you don't generally have any, you don't really have asset protection. You do have asset protection when it comes to like husband and wife. So in that respect, you maintain those same protections, but as far as a general rule of thumb, it doesn't give you any special asset protection. There's one thing that we do draft in the trust documents that we do. It's called a spendthrift provision, and what this does is it protects the beneficiaries. So God forbid somebody's child or something is involved in an accident or whatnot, and you know, you get that letter from Dan Newland to try and, you know, to do a money grab. in those kind of situations, Dan Euland can say, hey, I know he's a beneficiary for this trust. I want some of that. I want some of his. I want you try to force a distribution while the settlers are alive. So in that respect, you can't have another party kind of like try and force a distribution of that property.
So like, God forbid, my son, he turns 16. I buy him a brand new Honda Civic SI Sport. He's zooming down the street, puts it in fifth gear. He rear ends someone, and upon rear ending someone, that person realizes this is a nice car. I think I need to go after this guy. See what he's got, clean his pockets out a little bit, and he gets to sell me beyond my simple insurance policy. Dan Newland, whoever these people are, they can't come to my son's money set aside. Is that kind of how it works?
That's what it does. Yeah. So Daniel can say, hey, yeah, I'm gonna force you, the settler. I'm gonna force you to make that distribution to your son so that he can attach to that money, or he can try and have access to that money. So in that respect, it does protect them.
Okay.
Can we get to a couple of these ones, because I think it's closely tied in with this before we get into the the healthcare stuff.
Right. So
which
where
is
we are now,
the one about, actually, if you go to the bottom, that the idea of a trust is, the question is it in addition to a will, not to replace a will, and would having that avoid the probate? And there's also another question similar to that on the on Facebook. Let me pull it up. No, it's here. Can you do both a living trust and a will? So could you explain how that works? Do you have both? Do you have just one?
So if I can take that one. If we're doing an estate plan where we're gonna do a trust, generally we always advise our clients to do a will as well. And some of the benefits Siraj had highlighted was specifically referring to burial, and if there's children, guardianship. Because in a trust, you're not going to be able to nominate a guardian, and you're not going to be able to set out your burial request in a trust by itself. So what we generally do is what's called a pour over will, and so that has that if there's basically anything that wasn't specifically put into the will, that you want that particular asset or that property to go into the trust, excuse me.
So they go hand in hand.
They go in hand. So you have a what's called a pour over will and a trust, and those two are like peanut butter and jelly. They go together.
They don't go together, peanut butter and jelly. Where are you? Okay.
And actually, there's a question, I'm going to kind of edit it, we'll add to it, which says, if you have a will that says it should be Islamically distributed, will the probate court honor it? I have heard as long as there's no disagreement among the family members, it goes smoothly. And I would personally add to that, I have seen some of these pre-made online wills, which just say, in the case of my death, my assets should be distributed according to Islamic inheritance law. So how do the probate courts handle that then?
So generally speaking, obviously every court's different, every judge is different, every jurisdiction is different. There have been some courts who have said that they are not going to honor the Islamic inheritance law because they feel like it is against public policy, in the sense that, according to the law of Florida and most states, surviving spouse is guaranteed a certain amount many times, which is above what the Islamic inheritance, sometimes calls for. So at that point, they might have hesitancy to go by that. But if there is no disagreement and all the parties sign off, you can, you might be able to have that happen, but it's not a given. And I think that's too great of a risk to take for public policy reasons, for making sure that there's no families who are in disagreement. Because I've seen this amongst very religious families. I'm dealing with the situation now, a very religious family. The two are, one's an imam, one is, the other sibling is giving dawah regularly, but the father who passed away, he didn't have a will. Mashallah, he was a well-to-do man. And the siblings and the spouse, they are fighting amongst themselves because the more religious ones, they're saying follow the Islamic rulings on what needs to be done. Whereas some of the others are saying that, no, why would I do that? The law of the land says X, Y, Z. We live here, let's follow the law of the land. So to prevent that, it's better to make sure whatever you want, get it down in writing and get it legally, make sure it's legally sound. Do you want to add to that?
Yeah, just to kind of just to add a little bit, I'm sure if you've been in the community for the last several years, you remember that there was always that announcement on Friday regarding the anti-Sharia bills. As we would come like it would be like almost like a yearly thing that we would hear that we would want to express our concern regarding that. And then I remember the last time there was one that was passed, but I don't know if you guys recall that it was one of those very, very watered down, that it didn't really target Muslims in general, but it was kind of a very vague bill that said that if something violates public policy, then it won't stand. And that's kind of the general rule, like Siraj had alluded to that not too long ago, is really it's reflected upon if something will violate public policy. And so if you that's kind of also in the realm where we want to keep things as private as possible. And we also want to instill in our children when we talk to them that that this is the way that you want things done, and that way so that there's no surprises in the end, and then everybody knows exactly what is going to happen.
Um, so there are a couple more questions. We will come to them unless there's any disagreement. I do want to move on to the next. We'll come back to these certainly, but I do want to move on to the next portion, which deals with living wills. In some places they're called living wills. Some places they're called healthcare directives. Some places they're called different things. But the general gist of a living will is that allows for you, while you're mentally sound, while you can make your own decisions, to on your own decide your end of life decisions. And again, this is a very difficult topic, particularly in light of everything that we're seeing now. SubhanAllah, I'm just reading today in Florida that I'm seeing the list. There are many doctors here. I'm sure that they are concerned on their end that we haven't reached near peak level of what this COVID is going to cause. And already in Florida, I think almost 2/3 of the ICU beds have been occupied already. And we ask Allah to protect everyone and make this be resolved as quickly and as as quickly as possible with the minimal amount of consequences. But what living wills do is that God forbid, if someone is in a situation where a doctor says that they're incapacitated and there's no future chance of survival, you, as the person who makes a living will, you make your own end of life decisions. And what along the fact, one of the reasons obviously that you can decide what you want, but another very practical reason is that I'm sure that if you've lived life long enough, you have seen families literally tear apart at the seams over what to do with a beloved parent or a beloved sibling. There might be a slight, the doctor's saying that there's no chance, but it's a very difficult choice. No one wants to be the person that quote unquote pulls the plug on someone who is a dear beloved person or a parent or a sibling. So we recommend having these living wills so that the end of life decisions, they are in your own hands, so that you don't cause, number one, enmity or problems between your surviving family members. Because when emotions are high, the shaitan, the devil, that is when he has the easiest time to tear people apart. And I'm sure that if I ask you, have you ever seen this before? Everyone will say, yes, I've seen this here, I've seen this there. So proactively, this is a living will. What it does, if you sit with a lawyer, you can determine, you don't want to be unnecessarily prolonged if two doctors say you're in a persistent vegetative state, or if you have an end-stage condition and you're incapacitated. So you can, by and large, you can determine what you are most comfortable with, and it's a good idea to do, just so that you save the headache too, or the stress of someone else having to do that. You take control of your own end-of-life decisions. Yes.
And if I can add to that, something profound my father told us when he was drafting his document. And obviously, it's very difficult to have this kind of conversation with a parent and to confront their mortality like this. But he said that, I owe it to you to do this, because I don't want you guys to have to make a decision that's going to sit on your conscience for the rest of your life. So I'm taking that decision out of your hand. So, I'm encouraging everyone to have the same approach. When you do this, you're not doing it only for yourself, you're doing it for your family. You don't want them to live with that type of decision. You don't want them to have to make that decision. It's better you make the decision for yourself, put it in writing, and can you also go into how you can make sure that the hospital honors that? What steps should you take?
Zubair, you have real life example of that, right?
Yep. Sorry, I was on mute. Yeah. So when my father had a procedure done a little while ago, we had drafted a living will and healthcare directive for him. And when he went to right prior to his operation, they had asked, do you have a living will or healthcare directive? And he said yes. We brought it, and they made actually copies to keep it on file. So generally, if it's something that's not in like an emergency type procedure, it seems as though like if you're going for an elective procedure, usually the staff will ask if you have such documentation, and then they will make a copy of it and keep it on record for them.
Right. And I just want to chime in that just like for wills and trusts, there has to be certain guidelines which are met, having two witnesses who aren't, people who are directly related type situation. So also for these living wills, for it to be valid, it needs to be in many states notarized along with having the witnesses. So you're just writing it down again without meeting the proper statutory legal requirements, that's not going to necessarily hold weight in the hospital, because obviously they also are concerned about liability on their end for a variety of reasons.
And practically speaking, considering this situation that's going on right now in many hospitals, it's very dire. And, the unfortunate reality is that if someone is admitted to the hospital now, they have to go in alone. So, as terrible as this sounds to say, we should be prepared and have a file with documents ready, especially if it's someone who has health conditions, someone who has very specific, requests as far as, their living will, to have those documents on hand and even to take it with them, because the situations are such that the hospitals are just so swamped right now. They're not normally they would have social workers involved and a lot of people discussing, but doctors really just are forced to make decisions really quickly right now.
All right. Are there any questions about living wills, in particular, before we move on? I do see there are some questions. We can come to them. We'll get to them, but living will questions. If you have specific questions, we can sit down with you, go over what the text of many of these living wills are. You explain to them, but it's an important document to consider having. The next thing we'll talk about, along with living wills, is something called a power of attorney. And what a power of attorney is that essentially what that does is that when you sign and when you make a power of attorney valid, basically you effectuate it, that allows for someone whom you trust, and you better choose someone whom you trust, to many times act on your behalf. So for example, God forbid, we're in the situation where we are too sick to go to the hospital, to the banks. We are too sick to conduct our businesses, deal with, if we have an older relative dealing with Social Security, all of these things, that, sometimes do come up. What a power of attorney does is that it's a legally binding document. It's in statute. It has to be accepted as long as it's a valid document. And that allows for a spouse or a child or a sibling to conduct your business affairs on your behalf. So, you can designate what you want for them to do. So if you want for them to handle real estate matters, banking matters, tax matters, whatever matters you want, you will allow, that allows for someone who you trust to kind of handle those affairs for you. And, it's a very powerful document in the sense that, it gives in many ways someone to act in your capacity for a wide variety of things. So we always, whenever we draft these, we explain the implications. But if you have a spouse and you have an account just in your name or business just in your name, it might not be a bad idea to kind of have in your back pocket for that person to use if needed or as needed.
Yeah. So what you mentioned about that, because a lot of people have separate accounts. So does that mean if someone, you know, has a separate account from their spouse and their spouse's name is not on it, they're not going to be able to get automatic access to it. So they need to have this technically. Is that correct?
Technically, yes. You can be married. You can have a nice smile, go and be like, "Please let me access it." But absent legal protect, absent the legal rules,
It
they're
might
not
work
going,
for you, no one else.
it's not going to work. So yes, that is correct. And we can.
And another question is, if does that only apply if the person is incapacitated, or
No,
they can use
it
that
can.
anytime?
So basically, once you, it's called a durable. In many states, durable power of attorney. So once you draft it, that person has the ability to conduct business matters or matters on your affair up until the person who drafted it's passing. So whether you're capacitated or not, that person has the ability to do these things. But number one, it starts when you. So it has a finite life. It starts when it's signed, and it ends upon the death of the person who granted you the authority. You're muted, Mr. Zubair.
Just to clarify, Siraj, so if you drafted me if we drafted a durable attorney for me, and I made you my agent, and I designated you to be my power of attorney, and I pass away, will you still be able to act on my behalf?
No. So may Allah give you a long life with many goodness. But once you pass, my power of attorney, along with me being sad on your passing, that power of attorney will no longer be a valid document.
One other great question that was in the Q&A was regarding to, like, so say for example on this power of attorney we drafted, does that mean you have like 100% of control? Can you do anything you want on my behalf?
Yes.
So
you have to be very careful.
So what are some examples so that people can be aware of like what they need to do?
So when we draft these powers of attorneys, we specifically list out the rights which you are granting to the person, right? So you can add, you can take out, so you can say, I want for this person to be able to, for example, collect rent and deposit, go to the bank and handle this matter, but I don't want for them to be able to sell property. So you can craft it kind of as needed. But many people, when it's drafted by its language, a lot of these documents, they are pretty broad. So if you want to narrow the scope, you have to see with whoever's drafting it and narrow the scope to tailor it to your specific situation.
And then, sir, there was also a couple of questions regarding, so if someone is married, can either spouse have power of attorney to act on behalf of the other spouse? So can we designate, so in my scenario, can I designate my wife to be my power of attorney? Yes. And vice versa? Can she designate me?
Yep, that's probably a good idea because that's the person, I would hope you trust your spouse enough to, I would hope so, right? So there are some questions here on the Facebook regarding power of attorney. One is, okay, so the cost we can get to that at the end. Let's see here. What are the other questions?
The paper copy one? If you have to take a copy of living will, do you have does it have to be a paper copy for the hospital?
We recommend, I'm sure hospitals have different things, but we recommend having a paper copy. But I had sent an electric copy before for someone in a situation, and then I didn't hear whether it worked or not, but I had sent an electric copy before.
Oh yeah, can you also talk about the importance of filing a copy of that power of attorney with your bank and other financial institutions?
So we've actually recently, I came across a client who we did a power of attorney for, and it was a perfectly valid power of attorney, but her husband or her spouse, whoever went in with it, without her being there, and they gave her kind of a hard time. So she went in on her own. She talked to the banker, said, this is the power of attorney, my husband has authority. So they put it in her file to preempt any issues down the road. So if you do give someone power of attorney, particularly for banking purposes, where obviously banks are the most commonly what they're used for, it's good to, on your own volition, to go to the bank and register it in your file so that they have it.
And there's a good question here on the Facebook. Can a durable power of attorney be revoked?
Yes. It's very clear. We lay out in there, when it can be revoked, and basically all of these documents, they can be revoked very easily. A will can be, you can cancel a will out, a trust, revocable trust, you can cancel out, a living will, you can revoke, a power of attorney, any document absent irrevocable trust, which is something which is beyond the scope of this, it can be revoked. It can be easily revoked. Yes.
Sir, there's one question in the Q&A, but I think we might need a little bit more information. The question is regarding, I think, a power of attorney act only after your death. I'm not sure if they're requesting, if they're asking if there's a power of attorney that you could draft for someone after your death.
If that's the case, no, because at that point, you have to either you have a will and the judge appoints that person as the executor or the person who's going to do what the will says, or if you have a trust, the trustee who you designate after passing, that person will basically serve as the role of the trustee. But having a power of attorney for someone who passes away, that's not something which is allowed. Power of attorneys, by their definition, they are valid for the lifetime of someone who gives the power.
Siraj, one question I have is, so like if you do a durable power of attorney for me, and I make you the agent, would you be able to have access to safe deposit box as well?
You can put, so the one that we use regularly, the power of attorney document that we use regularly, there's an option in there where you can sign, you can initial and sign and say, yes, I also give Mr. Siraj the keys to the secrets in the whatever's in my box. Yes. Yep.
Thank you.
Can you answer this one about it? They're asking what's the difference between revocable and irrevocable? And I think they're asking which one you had mentioned earlier. Was this for the power of attorney or the trust?
Zubair, you can answer that.
Trust. So a revocable trust is what we were discussing earlier, and that it means that it's a trust that you can change and modify, and basically, like Siraj was saying, you can cancel. So you can do a lot of different things with a revocable trust. An irrevocable trust, it means that you can't make changes to it. So once you do it, it's more or less set in stone.
Absent everyone agreeing, but it's more so. Irrevocable trusts are used in very specific situations. They have different implications. They become their own entity. So just like if you start a business, you have to get a tax ID and do everything separately. With irrevocable trust, there are certain other requirements that have to be met. A tax return has to be filed for it regularly. So if someone feels like they need an irrevocable trust, let us know and we can tell you, the implications and work through, what that means. So where we are now is there are questions about relating to the estate plan. What we are going to do now is we're going to transition into some of the stimulus plans which were enacted by the president and enacted by the governor in Florida. Many people have contacted us asking questions about it. So we decided that for the benefit of our viewers and for our fans and friends, we can go over that too. Before we do that, there's a couple open questions. You want to go through those and then move on, or what's up to you guys?
Easy, whichever is easier for everyone else.
All right. So yes.
Yeah, maybe just finish off these few will things. Like
okay.
Someone said, I just moved to Florida. Most of my assets are out of state. Do I need to register the will in Florida or in that state?
So how wills? Was anybody want to answer that?
Go for it, sir.
Okay. So how wills work is that they have the ability to be, as long as it's a valid will where you are, just like you have a driver's license. If you go somewhere else, the license is valid. Similarly with wills, if it's drafted legally in one place, it can be implemented in a different state. But we recommend if you move to a new state to make sure that things are done according to their unique particularities, to basically update and create a new will or estate plan, which is in compliance with what that state says or what that state has. Does that answer the question? If there's any, if it's a follow-up, let me know. We can answer that. What's the next question on the list?
Well, there's one coming back to the power of attorney. What are some examples where it is a good idea to set up power of attorney? And I would add to that, do you think everyone should have a power of attorney or not?
Zubair, go and answer that one. Okay.
Sure, I think it's definitely an important mechanism that everyone should have, because you don't know when a situation is going to arise. And so I think one of the points we're trying to emphasize is that none of these documents can be drafted when you don't have capacity or you're unable to do them. So like if you're not of sound mind, you're not able to draft a will. That's one of the biggest things that can disqualify a will or a trust or any of these documents, is because the whole idea is it needs to be that the person who's drafting the documents is in sound mind. So those are the things we want, and especially in cases like if somebody's traveling overseas. Say for example, one good example I can think of, if someone's traveling overseas, now say they need somebody to do something on their behalf, or they need some funds to be transferred, or they need a property to be sold. We've seen the actually people acting with power of attorney to transfer property. That's not uncommon, especially if somebody is traveling frequently and things of that nature. Sometimes things have to be done and time is of the essence. If you don't have a power of attorney and you need certain transactions done, it's going to be very, very difficult to get them done, barring having a power of attorney. Also, they come into, it's very important if you do become, God forbid, someone becomes incapacitated and they're in a hospital bed, if there's things that need to be done, if they don't have the necessary documents, then somebody else won't be able to act on their behalf. So those are some of the some really, I guess, prime examples of situations where you would definitely want to have a power of attorney.
Having said that, the one caveat I always like to give is give it, if you're going to, when you draft it, make sure the person you're giving this authority to, you trust them, you have a fair amount of trust in them because of the powers which are granted. Just as my caveat that comes along with it. What are some other questions?
Let's see. Let's do, is the living trust honored between state lines, or is it just applicable in the state where it's drafted?
Generally speaking, obviously every state, we can't speak upon every state and every unique situation, but generally speaking, they will uphold if it's validly done in that state. But you still have to be careful. You don't want to be in a jurisdiction where they won't. But generally speaking, they courts will, if there's no dispute upon it and there's no issues that people raise related to it.
Okay. So I'll leave it up to you guys if you want to take a few more questions or move on to.
So what we'll do is we'll move on because it's 9:20 now. We'll move on, get this last piece done, and then we'll come back to the questions, I think.
Yeah. And then just for the sake of time, I'll try and run through these a little bit quickly. And if there's any questions regarding that, we can go over it. But recently, I know we've all been watching the news and have been informed about the stimulus package that had come through. And a lot of the questions we've been getting is, am I going to be getting any money? And if so, when am I going to get that? And so that's why we kind of wanted to give a little explanation of what's going on there. So the stimulus package, it works in a couple of different ways. One is if you file your taxes individually, your AGI, and that's if you look on your 1040, it's a section.
1040 is your basic tax return.
Your tax return, right? If you look at 8B, 8B will give you your adjusted gross income, and so if that is 75,000 or less, you would qualify. And it goes up to 99,000. So any dollar amount above 75,000 to $99,000, the amount that you get gets reduced. So provided you meet the requirements, you'll get a payment of $1,200. If you are married filing jointly and your AGI, your adjusted gross income, is 150,000 or less, then you would qualify and you would get 2,400. But if you're above 150,000 up to 198,000, it gets reduced as well, depending on how much more. And so based on those, you'd get a calculation. And then separate to that, if you qualify, you can get you can get $500 for each qualifying child. And the qualifying child is a child who is up to the age of 17 or under 17. So depending on if you have basically a married couple, they make say 150,000 and they have 2 children, they would be entitled to a $3,400 check. And what they're doing is, if you filed for 2019 your tax return, and you have gotten a direct deposit for when you filed your taxes, they're going to be deposit that money directly into the account. And the one thing is so if you're a married couple filing jointly and you're above the $198,000 threshold, you wouldn't apply to the stimulus package, and you wouldn't be able to collect even the $500 for the children. And we put the calculator there. There's an H&R Block. They have an actual calculator, so you could put your particular set of facts, and you can put it in there, and you'll be able to calculate what payment you should expect to get. And the question is, so if you're applicable and you can, you fit the criteria, when are you going to get a check? that's one of the biggest questions we've been asked, and the answer is hopefully sometime in April. They haven't said an exact date, but they've said that they're going to try and do it in April. And so that
having said that, there was a caveat that I saw today where they were saying that if there's no direct deposit on file for them, it might take them longer. They're saying up to, I think, 20, I was saying 20 weeks, I think what was in the news today. So there's been going back and forth. We don't know, but they're saying best case scenario, if they have direct deposit on file, they're going to start working on these sometime in April.
Sure. And so that's for individuals. So moving to the
one thing I don't want you to do before we move on is that the good thing about this one-time payment that people who are eligible are going to receive is that there's no tax consequence for it. So generally speaking, if you make money, that becomes a taxable event. You got to pay taxes on it. But for people who qualify for this one-time stimulus package payment, that's not going to be taxable for them. That's just money free and clear.
That's important. Thanks, Siraj. So if we go to, the small business side, they have what's called the economic injury disaster loan. And the reason why I wanted to bring this one up is because it is important. And there are, some of us maybe have small businesses and things of that nature, but there's an eligibility to get a cash advance up to $10,000. And the way this works is that $10,000 is, even if you apply for a government loan and you get denied, that $10,000 you'll get, and it's going to be forgiven. So it's going to be, that actually turns into a grant, and you won't have to pay that back. So it's important that if you are in a small business and you meet the criteria, that if you're affected by this disaster, that you would want to file. And the one thing about these loans is that you want to file sooner than later, because there are the money and the funding can run out. So that's so say for example, you do the 10,000, you file for it. If you are filing for a subsequent loan, if you are granted that loan, that $10,000 will be taken out of that subsequent loan. So it'll come out somewhere if you go to the next step. And that brings us kind of to the payment.
But before we go on, one question. So these monies that the Small Business Association and they're getting out, can they be used for basically what we want to make sure is to avoid the interest aspect of it? So to have that done, do they have to be used for specific things, or how does that work?
So you would want to use it for, it basically is for for first 10,000 is really used for working capital. So you would want to use that towards business expenses or something related to the business, particular payroll if it can, and other operating expenses. That's what they've kind of referenced quite frequently. And then it's more so explained in the payroll protection program, the PPP, that they've been talking about quite significantly. And with that program, you apply for, there's a couple things that are very, very important. As of right now, there's no, there's no personal guarantees, which is very, very big. Anyone who's in the small business world knows that if you're doing any kind of loan, you're personal guaranteeing, whether you're buying a car, buying a property, buying anything. You have to personally guarantee it if you're doing it through a business. So right now, it's not something that you have to personally guarantee. It's available to small business and nonprofits. So if there's a nonprofit that's been affected, it's important to look into these types of things. And so basically what they've done is they've said they look at your average payroll amount for the last year. And so they take your average month, your payroll cost per month, and the maximum loan you can get is 2.5 times that monthly payroll amount. And what those funds have to be used for, though, for it to be a loan that could be potentially forgiven in the future, is that you have to use those loans primarily for payroll. And so the guidance that they've given is that they want you to use it at least 75% for payroll. I know they've mentioned that you can use it for some mortgage interest, you can use it for rent and utilities, but in the actual application, they are telling you that if you want it forgiven, you can only use the mortgage interest, the rent, and the utilities up to only about 25%. So the vast majority that you need to use it for is for payroll cost. And one important thing to note is that they're going to, if it's something that you are looking to apply for, they are going to require receipts if you want that loan forgiveness. So it's important to make sure that you're documenting what you're using those funds for, and you're able to provide that if you're seeking loan forgiveness.
Where do you go for these loans? For the $10,000 and for this payroll? Do you just kind of
if you Google SBA disaster loan, or if you go to the previous slide, if you type in the economic disaster loan, if you type the EIDL, if you just put that in Google, it'll come up. It's one of the first things. It's through the SBA website for the economic injury disaster loan. But for the payment protection program loan, if that's something that you're interested in doing, that's going to be done through banks. So if you have a relationship with a local bank here, it's important you reach out to them. But again, one of the main things with these funds is that the money is capped. So they have only a certain amount of money that they can be given out these loans. So if it's something that you're trying to do, I would advise you to that time is of the essence, and to try and get that done as soon as possible. I spoke with a banker today, and she told me that Bank of America received over 1 million applications already.
Really? In one day?
In one day, and it just opened up today. So April 3rd was today was the first day you could apply. So and just with that said, I mean, there's going to be a lot of people requesting funds for these loans. So if it's something that you feel like you need for your business and you've struggled because of the COVID-19 situation, I would advise that you do it sooner than later if it's something that you would want assistance with.
So at this point, I think we can take questions. That, in essence, wraps up what we wanted to cover in relation to estate planning and in relation to the stimulus packages options. And the reason why, we initially weren't going to bring up the stimulus package options, but I personally have received many phone calls from clients, from friends, from people that I know. Like, obviously everyone is very stressed out right now. Business has come to a standstill. Unemployment, I think, is going to essentially, they're predicting it might be higher than what it was during the Great Depression. People, wealthy, working class, everyone's being affected by it. So we just wanted to, briefly go over some of the options available. If there's more detailed questions, a couple of nonprofits have reached out to me. We worked with them a little bit to see what's available for them. So if you have any particular questions that are unique to your situation, feel free to let us know, inshallah.
Sorry, I'm just gonna get this one. There's two questions here. So one of them is related to the stimulus for the children limit, and as far as I've read, there's no children limit.
No, there's no. Yeah, there's not. I don't. As long as they're under 17. So like if you have a 18-year-old or they are not eligible. So as long as they're essentially 16 and younger, 1, 2, 3, 4, 5, no problem, inshallah.
Inshallah. And then there's a question regarding: is there any way to avoid the interest with the SBA program? Are there any Islamic banks part of the SBA program? I don't believe there's any Islamic banks part of the program. There's a couple of ways. So basically, the way that you do it, there's a two-tier. If you're looking for just a complete 0% loan that you're gonna have to pay back, Florida, the state of Florida, if you Google Florida disaster interest-free loans, they're offering $50,000 up to $100,000 at a 0%. For 12 months.
That's that bridge thing you're talking about?
Yeah, that's a bridge loan. So they're offering these type of loans. So if it's something that you want to look and see, you can potentially use that avenue. But generally speaking, Siraj can touch more on this, but I'll just give just a slight, I guess, preview, and then Siraj can follow up. Is that the way these are working? If you do it correctly, you should be forgiven completely for the loan. So that you're not going to be making any payments toward the loans. As it is for the, if you use the PPP, its payments are deferred for 6 months. So as it, and there's a 2-year maturity on those PPP loans. And if you follow the rules correctly, then you should be entitled to full loan forgiveness.
It's just important to follow. There's very particular rules. Like you can't pay to someone who's making over a certain amount. If you have a mortgage on a property you want to pay, it can go towards the interest, but not the actual principal. It has to be used up to a certain for payroll. So there's very specific rules. They're laid out. So it's just making sure that you follow those rules and you have a very clear paper trail. Because if you're going to be questioned, you want to make sure that your paper trail is very clear and very easy to follow.
And just to follow up with what Siraj is saying, and so it's important that you just follow the rules, inshallah, and then hopefully that if you do it correctly and you follow it as it's supposed to be, that the entirety of the loan should be forgiven and there should be no interest incurred. But to that extent, Siraj, I don't know if you want to touch base upon some of some of the things that you've read about regarding the Islamic permissibility of, if you're in this situation and
obviously this is this is a novel issue. None of us are here are scholarly enough to get into the Islamic issues regarding this. I can share some fatwas that I have seen from some scholars regarding it, but if you're going to take it on, speak with someone who you trust Islamically, and also speak with an accountant or a lawyer to make sure that you're covered on all aspects. That's what I would say.
The one thing I forgot, that's what I actually wanted to say, is that if that brother or anyone else, they want to reach out to us directly or talk to us about that, we'll be happy to help regarding kind of going over your specific, unique circumstance and regarding trying to apply for these loans or wanting to discuss it in more detail. We'll be happy to do that too, inshallah.
So inshallah, now we'll go ahead and start working through some of these questions, I think. Inshallah, Mariam, you want to take us through some of the questions? I'm not
sure.
Why don't too many boxes open on my screen, and it's
well, so it says one of the questions is, if I own a property and I'm gonna, it's some words are missing, but I believe what it says is my wife is not on it, like her name is not on it. After my death, does it go automatically to my wife or not?
Zubair, you got that one. You like these questions.
So automatically is the question. So automatically it would be difficult. She would be entitled probably to it if there's a probate matter, but generally speaking, that's why you'd want to have the deed done properly to make it husband and wife. If you do something as joint together, husband and wife, then they would own 100% together. And if you do it that way, if the structure is that way, it'll be better, because then on the passing of one, the other individual, they are the 100% owner as well. So there's no documentation, there's nothing that needs to be done at that point.
It just passes on. So it's called tenancies by entireties, that spouses have that if a property is bought in the duration of a marriage and both names are on the title, on the deed, then it passes on just kind of as a matter of law to the surviving spouse. That's if the spouse's name is not on it, it's not a given.
And so the next question is regarding the social distancing. How do I get the will notarized or witnessed? So it's going to be effective in July, but there is the possibility of doing an online notary wherein you can, do things telephonically. I mean,
not telephonically, like kind of like this.
Online is kind of like this. It's like, it's almost like a FaceTime wherein you can do an online almost witnessing notary situation.
In the state of Florida, what's going on right now is in January of 2020, Florida, for some transactions, they allowed for remote online notarization. So like now closings for property can be done online. A lot of documents can be notarized online. For whatever reason, the state legislature, they decided that in the case of wills and trusts and these type of documents with estate planning, they're going to allow for it to be notarized online starting in July. There's, what's going on now legislatively is that the Florida bar and attorneys and people who are involved in this, in light of social distancing, in light of the fact that these documents are now more important than ever before, and we are being told that, keep your distance, stay apart and don't unnecessarily meet. So they're trying to see if the governor or if legislature would allow for things to be notarized remote earlier. But where we are now is, work with us or work with a lawyer, because according to all states, whatever state you're in, that have stay-at-home orders, legal services are considered to be essential services. So, lawyers can work with you on that.
All right, so you want to take this one. Does everyone need, both of these are power of attorney related. By default, will your spouse have power of attorney, then children? Yeah, well, let's do that one first.
Zubair, you want to answer that?
No, the answer for that one, if it's not designated, no. Unless, again, so it depends, it also depends. A general durable power of attorney, no. But if there's, like, again, with spouses, there's certain things that the spouses could do For example, if there are spouses on the bank accounts and things of that nature, depending on what the spouse is on, then potentially they can do certain things. But as a general rule, and to do everything. So, say for example, if the one spouse has a business, the other spouse won't be able to act without that durable power of attorney on behalf of the granting spouse. Do you want to add anything to that?
No, I think that's good.
So for Florida residents, in the will, does the executor have to be a Florida resident or citizen?
No, and I believe in every state, the executor doesn't have to be a resident of the state as long as they're an adult and they submit and they're willing to serve in that capacity. That's not an issue.
I think Siraj even had a probate case where the personal resident ended up being from, was it Pennsylvania, Siraj?
PA.
Yeah, Pennsylvania, and they came down to do it. The only thing we could add for that is also just sometimes just kind of be cognizant of logistics, because if it's only a will, if there's a lot of assets, sometimes it becomes a little bit more complicated, and time-wise, there's more time involved, and Siraj could attest to that.
Yeah, so like that person who was in Pennsylvania, the relative had some property, an outstanding HOA issue, work, benefits, a lot of things that took up the personal representatives. It was time consuming, and him not being here for some of the matters, it was a little bit difficult for him.
Okay. Now, what are your thoughts on setting up an LLC for estate planning? So placing all your property in an LLC, then adding the children to the LLC. Is that a practical, or is that a good plan?
Siraj, do you want to take that one?
You can go ahead.
I mean, it's hard to say. It all depends on the unique circumstance. As a general idea, I don't know if it would be considered an estate planning technique as much as it would be considered more of a way to, I guess, a certain business structure. But there's also other things to that you'd have to take into consideration. If you put an LLC with properties, and depending on the children, just know that if there's income coming in, that there's going to be tax consequences for that as well. So there's certain things that you'd want to look at, prior to setting that up, to see if it's in the best interest of all the parties to do it that way.
All right, and then we'll finish. Oh yeah, go ahead.
But when Zubair was saying that having a revocable trust is not an estate planning tool, many times with individuals who have businesses or properties or other assets, for the asset protection side, we do sometimes create LLCs for asset protection and tie them into the trust. So sometimes, depending on what assets you're looking at, they can go hand in hand.
Yeah, that's an important point to add. So what about, we'll finish with this last question. These two questions kind of relate to each other. So whether it's power of attorney, will, revocable trust, should each member in the family over 18 get it, or is it just husband and wife? Is it one document for just the husband and wife? And then, this ties in with the other question, which is that, is it sufficient if only one spouse has a will, if both spouses share ownership, or should they each have their own wills?
Zubair can answer that, and then I think.
It's important to have both parties to have wills. Again, especially if you have, minor children. If one spouse passes away prior to the other spouse, and the surviving spouse doesn't have any guardianship provisions and they didn't have a will, then the other spouse having a will is not going to have any force and effect on the surviving spouse who just passed. So it's important that both parties have wills. It's definitely, it's better to have it that way, because there's, each one has their own individual requests and things in its specific will. So it's important that each individual has their own will.
And certainly in these times, we're seeing it's normally, when you think about a husband and wife passing away at the same time, you're thinking about like a car accident type of situation. Whereas now, unfortunately, it's sometimes both are getting sick at the same time.
Right. And I saw several questions about cost. Obviously, right now, everyone is in a difficult situation. So it's difficult. Every plan is unique. Everyone's situations are unique. So if they're contact us individually afterwards, we can sit down and, discuss the, pricing and cost with you, I think on an individual level. It's hard to give, a blanket cost depending, because everyone's situation is just so unique.
Okay.
Are there any pending questions on the Facebook side?
Nope. We're all caught up on those questions. Yep.
Are there any other final questions? So this was a little bit long. If anyone has feedback they want to give us, that would be, nice too. If anything that you feel like we could have done differently, or anything that, just general feedback, we take this very seriously, not only from a business perspective, but, as this in many ways is a fard kifaya, it's a communal obligation for the community to have the knowledge and to make sure that these matters are resolved and manners are taken care of. So since you are the community we strive to serve on many levels, any feedback, email or whatever, just let us know, inshallah.
And I would just add something, for those who are listening, and this is not from the legal aspect, but just from the emotional aspect. We understand that these are very difficult issues to talk about, especially when you get to things like medical advance directives. No one wants to think about these scenarios, but as the current situation that we are now in worldwide really is forcing us all to confront these issues. And so, as difficult as it is, we strongly encourage everyone to have these conversations with the family and to be on top of this, and and to let everyone be in the family be on the same page. It's going to save you a little bit of pain, and discussing these things now will save a lot of pain later on.
There was one question that I think just popped up. It said, "Do children above 18 also need to make a will?" The answer to that, Siraj, correct me if I'm wrong, is if you have Islamically, if you have anything, if you have something that you can give, then you should make a will. Is that correct, Siraj?
Yeah, I mean, 18. Once at that point, you're responsible. So if you have anything which is inheritable, it needs to be written down and it needs to be documented. It needs to be documented in a legally valid way. Yes.
And it's interesting that it's interesting. There've been a few questions about over 18 children, and I'm going to put children in quotes because legally, from both legally and Islamic perspective, they're no longer children. And culturally, we oftentimes treat them as children, but, we have to recognize and we have to explain to them as well that they're responsible in front of the law, and they're responsible in front of their Lord because they've reached the age of puberty. So they really have to be, take ownership for these adult responsibilities. And that's one way we as parents can guide them in that direction. Alrighty.
So inshallah, I think we
So we'll
have
finish up.
wrapped up questions. Thank you very much for taking time out of your social distancing life to have a virtual party with us tonight. May Allah bless you and your families. And any other questions, let us know, inshallah.
All right. Assalamu
Alaikum.
alaikum. Thank you very much for everyone joining. Yes, those who have joined by email, there's a question. Will we send a link to the recording? We will send a link to the recording. If you do have Facebook, you can go to the Facebook Live Dawood Sohail Law or the Muslim Educator, and it was live streamed over there, but we'll also send the recording. Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh.
Assalamu alaikum.